All right, welcome back. Welcome back. I still don't get it. You can take it off if you want. It doesn't look comfortable. Is that?
It's fine.
Okay, pure dicta, as Justice Thomas would say. Yeah. A foot. We should be putting it on your foot. Happy Halloween, everyone. So actually, I'm at home now. So I left these pumpkins in front of my house with a note, and one said, "Take as much candy as you want, fill with chocolate." The other one said, "Fill with constitutions."
Oh, I thought the Constitution was the chocolate.
No. I have chocolate and constitutions, both.
You should have taped them together. You know that I know they should.
So I wrote a note. Let me see if I have a picture of this note. I do. Yeah, I got a picture. It happened. Where is it? Where is it? I'll show it to you. Happy Halloween. Oh, I should have done this in advance. Okay. Is it what? Yeah, it's recording. It's on. Okay, here we go. Yeah, so this one says, the living Constitution is a trick. Treat yourself to the original Constitution. And I came up with that last night, so I put these in front of my house with a little. But it's been raining all day. It's been raining all day, and I have a Nest camera. Not a single trick-or-treater, not one. I know it's pouring. Not one trick-or-treater came by. What? Anyway, no, I put them under a canopy. Don't worry, I thought about that. I would not degrade, please. Although one of my neighbors came by and said, "Declaration? What is that?" But I record everything. I have cameras everywhere. It's great. Nest is cool, though. It even recognizes faces. So it starts recognizing people walk by every day, and it builds patterns. And ooh, that's a good idea. Oh man, I gotta look at that next year. Okay, but anyway, so I think all my Constitution is still there. I cleaned out my pockets. I gave everyone the last one I had. Yeah, right. Okay. Use yours. Okay. So I know you're all going to ask. Let me just talk about this for a minute. It's very often the case that ConLaw, unlike other classes, actually has real-world implications in very timely fashion. So the last, 18 months or so, I've had this thing where I wake up in the morning and I check my phone and I check Twitter. I'm like, oh, okay, that's what I'm doing today. So, I'm sure most of you saw there was a interview with the president a couple days ago where but I do need to address it's a legal issue. I don't need to, but I will anyway. Where he discussed birthright citizenship. So let me pull back for a second from the question of what the president can do today and talk about this question as a general matter. And our discussion really begins with Dred Scott, a case we keep coming back to. And one of the premises of Dred Scott was that certain people of African descent, could never become citizens of the United States no matter what, even if their state granted them citizenship. They can't be citizens of the US, and they can't be citizens of a state, right? Diversity jurisdiction. Section 1 of the 14th Amendment sought to reverse that holding. And it reads, and I'll read it too. We've read this 100 times. Section 1 of the 14th Amendment. Blah. Okay. It says, I know by heart. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Okay. So if it simply said all persons born in the United States are citizens, then it'd be a open and shut legal question. But there's this phrase, subject to the jurisdiction thereof, right? What does that phrase mean? Now, I have a view on this that's not universally held. People disagree with me, but I'll give you my view and I'll give you the other view as well. And if you're interested, I have an op-ed coming out in the Wall Street Journal any minute now, which will keep refreshing this page on this exact point, but you get to preview. There are two types, or two general types of citizenship, and different countries have them. In some countries, you inherit your citizenship from your parents, right? If your parents are a citizen of country X, then you are a citizen of country X. You don't ever have to go there, okay? In other countries, you have what's often called birthright citizenship. That is, if you're born within a certain territory, by virtue of the fact that you're born there, you are a citizen. Okay, so which one do we have? The predominant view, and this is pretty wide consensus, is that we have the birthright citizenship approach. Now, what does that phrase mean? Subject to the jurisdiction thereof. I think the better understanding, and it's not the only one, but the better understanding is that subject to the jurisdiction means subject to your laws. I'll get in a few minutes. Oh, where is it? Is it? Which one is it?
Let's see. It's below. It's like birthright citizenship.
Oh, there we go. Josh Blackmun. I see. Okay. There's a constitutional mandate. I don't write the headlines. Okay. Perfect. Right. Is the child of a gypsy born in Pennsylvania a citizen? Yeah. I'll get there in a minute. Okay. So you can here. I'll put the link here so you can read along as I lecture. That's good. You get the real thing though. So the question is, what does subject to the jurisdiction thereof mean? I think the better approach is that means you're subject to our laws. So if you're an immigrant, you come here, you're subject to our laws, right? If you run a stop sign or you speed on the highway, you're getting pulled over. And you can't say your defense is, I'm not subject to jurisdiction. That's not going to work. You're going to get the ticket, you're going to get arrested, etc. Now, there are exceptions to that. So for example, if you're a diplomat, if you're an ambassador to a foreign nation, you come to this country and you break a law, you're probably not getting prosecuted. There's a general norm of what's called immunity for diplomatic officials. And the reason why is obvious. We don't want to screw up our foreign relations by putting ambassadors from abroad within our criminal justice system, right? You can deal with this nation to nation, send the diplomat back to their country, and then we'll deal with it another way. Another exception is perhaps certain Native American tribes, right? They indeed maintain their own sovereignty. They have their own government. They can have casinos and other things that we can't have in our territory, right? So there are some people in this country who are not subject to our jurisdiction. And I think the better reading is that subject to the jurisdiction means basically everyone except for basically Native Americans, certain tribes, and ambassadors. That's the predominant perspective, not the only one. In fact, I think the way they set this up is there's a point-counterpoint. It's me and this other guy. Here, Matthew Spalding is the case against, yeah, there is. He's the case against birthright citizenship, and then I am the mandate, whatever. Okay, so debate however you wish. So, but let me give you his other side, and I do want to be fair to the other side. I always try. The other argument is that subject to the jurisdiction means subject to no foreign allegiances, right? Or it could possibly mean you have all the rights and responsibilities of citizenship here. So think of one of our favorites, Justice Harlan, right? Justice Harlan wrote about this in a case you read, which was Plessy. And if you remember, Justice Harlan made a very broad statement of how the 14th Amendment was designed to bring the freedmen back into the fold of our republic, right? But he said, but there's this other group, right? There's this other group that doesn't fit. And he spoke about Chinese people. And there was this long discussion where he said that they're not loyal to us. They're loyal to the emperor, right? They're not part of our polity. Harlan dissented in another case called Wong Kim-ark, which Jesse and I think Markia talked about earlier today. And Justice Harlan explained that certain groups cannot be subject to our jurisdiction because they're loyal to the foreign emperor. So the alternate view is that people have foreign allegiances, such as Chinese people, are not subject to our jurisdiction. So the argument today, right, that people born to parents who are not here lawfully cannot be citizens isn't new, right? It's not new. This was something that was actually debated at the time. I'm going to tweet in class, put this one out there. At the time of the 14th Amendment. And I'll just pull up this one quote here. I'll make this bigger so you can see it. Okay. So the precise question that's being debated today about, one second, I'll get you in a second, I promise. The precise question that's being debated today was debated 150 years ago. By the way, this is the 150th anniversary of the 14th Amendment, 1868, 2018. So there was one senator from Pennsylvania who said, quote, "Is the child of a gypsy born in Pennsylvania a citizen?" Right? Next, he said, this could be a tweet, by the way, just this sentence. "Is it proposed that the people of California are to remain quiescent while they are overrun by a flood of immigration of the Mongol race?" This could just basically be a tweet. You know, it reads like it. So the exact point that's being raised today was raised 150 years ago. And then another senator from California said that these children of Chinese and Gypsies people will be citizens. And he's ready to accept the provision. Now, this doesn't prove everything. It's not definitive. But the exact debate that we're having today was had 150 years ago. And if that's not enough to resolve the question, we have over a century of practice in which all three branches seem to agree that people born of foreigners in this country are citizens. And we learn in cases like Noel Canning and in Youngstown that practice is very important to resolve difficult constitutional questions. Justice Frankfurt called it a gloss on the Constitution. And actually, they let me put this in. I was shocked. Here. It's a gloss, right? I can't believe they let me put the word gloss in there, but I got it in there. So I'm teaching, not just you, I'm teaching everyone. I think there's a liquidation, there's a settlement, there's a settled practice. I think you need a lot more than some disputed statements to rebut it. Now, what did this guy Spalding say? I haven't actually read it yet. I probably should have read it before class. I missed the critic. Ridiculous. Oh, he's got the Lyman Trumbull. Okay, I'll read this after class. By the way, he favorably cites Slaughterhouse, which, I don't want to get started on that. I'll read this later. Okay, I'll read it later. Okay. But if you want to read it, go read his position to be the counterpoint. I don't want to, think just whatever Blackmun thinks is right. There's a pretty big consensus, but I generally don't think consensus means you win, right? You have to actually make your arguments. Okay, so several hands that I didn't call on you. So do you want to tell me the article's up? Kanisha, I think your hand was up?
Wasn't it, we talked about that same argument when we were doing, I don't want to say it right, starts with K.
Caroline Products? Crookshank? Korematsu?
That argument was made then too, right? We talked about that where they were saying that the allegiance to the
Yep.
country. So it is I didn't hear you mention that when we were talking about the previous arguments on the topic, but it was the same thing.
Yeah. I mean, the notion that specifically Chinese people, Asian people, are subject to a foreign power was a very common theme in American history, very common. It came up in Wong Kim-ark, the case I mentioned earlier, the Chinese Exclusionary Act, even in Korematsu, in the 1940s, that these people cannot assimilate, they're different, and that they are subject to a foreign emperor, and they can't be loyal to us. There's nothing new. It's the same thing that keeps popping up year after year.
So I didn't know anything about this article. So is his argument about a specific ethnicity again, or is he just saying period?
In general, he said if your parents are not here lawfully, then you are not subject to a jurisdiction. It's not limited to any race. And again, I haven't read his paper, so I don't want to criticize it, but I generally...
whatever Trump said at the start of this, I don't know it.
Well, right. Well, it's brought up in the... One time, it's brought up in the current context, but the arguments against birthright citizenship aren't new. These have been around for decades. I mean, so in other words, I haven't read his piece yet, but I could probably write it for him. I know what the arguments on the other side.
I was thinking about Trump, though, because I think his wife is, not here.
Well, she's naturalized. She's not a birthright citizen. Okay. Other questions? I don't want to take up the entire class, but it's pressing enough, and a couple of you asked me about it.
I do have a question.
Yes, sir.
Which way do you see it going if he does actually sign this executive order? Do you think it has a chance to get enforced, or will it just get shut down?
Well, let me answer your question in two different ways, right? First, I don't actually think there's an executive order. I think this is a tactic to generate attention for the election. I think there's absolutely nothing. Oh, this is awesome. Someone's taking a picture of my Constitution sign. I love this so much. You're welcome.
You can talk to them, can't you?
I can. I'm not going to. I'll freak them out. Now, do they take the Constitution? She doesn't take the Constitution. What the hell? Oh, come on. Come on. Okay. I got a notification someone was on my front stoop. Okay. No! After all that, she came and took a picture of it. All right. Okay. All right. Enough. Okay. So, shh. Okay. Anyway, so yeah, Drew, I do want to answer your question. So I don't actually think there's an executive order. I think this is merely a thing to gin up attention a couple of days for the election. But to the extent there is, it wouldn't be an executive order that strips people of their citizenship, right? Denaturalizing someone, right? Moving their citizenship is really hard. Like, we've had cases where they have like terrorists overseas who can't be denaturalized, right? Who actually tried to kill Americans, like John Walker Lind, if you remember back in the after 9/11, right? So it's hard to denaturalize someone. What they can do, which is probably more likely if anything happens, is they'll take a statute that says certain benefits are given to citizens, and they'll say we will interpret this term citizen differently than our predecessor did, and therefore certain people are not given citizenship, not given those benefits. That's a much more likely thing. Or they can say we will no longer give passports to the children of diplomats, makes them a little bit more specific, right? But I think this is bluster. I don't think it's real. I don't. A lot of my job is separating things that happen, things that won't, and this is my prediction. It's nothing. But who knows? I'm usually wrong. Yeah, Mark. Yeah.
So you actually have comments on your.
Oh, you're vague. No, I can't. No, I don't read the comments in my articles.
It's not bad. It's actually a good question. So
Oh, God.
the question was if-
This is the comment thread comes to life in my class. Oh, you're vague.
So you know how you said with like foreign diplomats. So if a foreign diplomat, if they have a child here in the U.S., that child wouldn't be considered a citizen. So why is it that someone who can come here illegally, their child would be a citizen? Or like in my case, when I was born in Germany, I'm not a citizen, or I can be president.
Well, I think you can be, because I think you, and I don't want to get into your specific situation, but I think you were naturalized at birth. I think you probably could be on some further reflection. I know, I'm sorry, but I think so. There's actually, so I'll give more general. John McCain, who is ran for president some years ago, was born in the Panama Canal Zone at a military base, and there was a robust debate. You might recall, was he actually a natural-born citizen? And I think the better answer that he was, and the reason why is that by virtue of the law in effect at the time, he was a citizen at birth. And I think if you're a citizen at birth, you're a natural-born citizen. So he argued he was natural-born. More recently, Senator Cruz, who was born in Canada to American parents, was challenged by Trump, saying you're not a natural-born citizen. And again, I think the better answer is that he was a citizen at birth, for the same reason that Marquis was. The statutes say at birth, you're naturalized immediately. You don't have to go through a process. You are a natural-born citizen. I think the better answer is that you are. Does that make you feel a little better? Marquis 2020? No? Okay, give yourself a little lead time. Oh, God. Okay. Okay, what else? Anything else on birthright citizenship? Okay. Oh, God. I never read the comments of people who comment my articles. It's a cesspool.
No, it's just one guy did it four comments. The other two are.
Whatever. Okay, let's go. Let's do actual ConLaw. So let's start off with this question to bridge our gap from last class to this class. And while I'm doing this, I'll read the comment thread maybe. So the question is this, right? Under Roe v. Wade, the state has an interest in protecting fetal life during the second trimester? That's your question. Okay. All right, where am I next? All right, Vincent, what do you think?
So, I say under Roe v. Wade, it's false.
Okay.
And the actual guideline that is given in the case says that it follows. Well, it says that a state may regulate the abortion procedure to the extent that the regulation reasonably relates to the preservation and protection of maternal health. So it's not really doesn't really have anything to do with protecting fetal life. It's all about the health of the mother and that.
Exactly. Yeah. Yeah. So, oh damn it! Some type on the last sentence. Crap. Sorry. That's the name of the publisher. Ah, damn it! Someone. That's what the comment now says. Okay. Damn it. Okay. So yeah. So let's talk about Roe again, right? Roe established this trimester framework, right? And it said basically in the first trimester, the state has really no interest in protecting fetal life. And the only sorts of regulations that can be passed are standard ones, licensing doctors, right? Making sure that facilities are clean, general stuff. But in the second trimester, you can start regulating stuff to protect the mother's health, like abortion-specific regulations. So maybe you can have certain standards for abortion clinics that are not needed for other types of medical facilities. But only in the third trimester, which is post-viability, months 7, 8, and 9, they say, can the state enact regulations for the purpose of protecting fetal life. Okay? Now, why am I bringing this up? Well, we'll see in a few minutes that Casey changes this framework a lot. But more importantly, do we usually think of rights as something that can be violated a little bit at this time and a lot at that time, right? Does this right to abortion fit in with the normal approach how we think about rights? Usually if you have the right, you have it. If you don't, you don't, right? If you have the right to abortion, you should have it all 9 months. If you don't, you shouldn't have it any of the 9 months. Roe is unique in that they didn't identify a right in the usual way we think about it. And I'll give you another example. We previously studied Loving, right? Loving versus Virginia. And that court held that as a matter of due process, you have a liberty to marry the person of your choice, regardless of their race, right? It was described as a fundamental right. And I told you that generally fundamental rights are afforded strict scrutiny, right? They're reviewed with strict scrutiny. But the Roe decision didn't mention the word scrutiny, right? It talked about fundamental rights, but it didn't use the normal word of scrutiny, right? Which created a debate in the years afterwards. What exactly is the correct standard of review for abortion? Either reviewed with strict scrutiny or maybe a rational basis or maybe something else. Casey would resolve that question by making an entirely third standard review known as the undue burden standard, which applies to abortion and only to abortion. Okay? But before we get to Casey, I want to do Bowers. And Bowers is an important point. I'm sorry, an important case, because it marks a point where the court was still using this framework for the due process clause. The framework was this: is a right, quote, fundamental? If it's fundamental, it gets strict scrutiny. If it's a non-fundamental right, it gets only rational basis review. And all the fight was, do we put yourself in the strict scrutiny bucket or not? That was where all the action was. By the time you get to Casey, they start moving away because they don't talk about those stuff anymore, right? So Bowers is a very good mark of where the court's still stuck to this fundamental rights approach. It doesn't really have much resonance now. It's been overturned, to be clear. Bowers is no longer good law. But it's a good transition from the sort of Warren Burger Court approach to how the Rehnquist Court handled these issues. Oh, by the way, I got to tell you this. Did anyone see the story about O'Connor today? Did anyone see this? Okay, don't ruin it. So remember I told you how Rehnquist and O'Connor dated? More than I thought. This is psycho, right? They went on 40 dates in 40 days. I'm going to get there in a minute. See, the job is timing, right? That's yeah, no, that's how I do things, right? So they went on 40 dates. See, you know the punchline doesn't work. They went on 40 dates in 40 days, right? And then he wrote her a letter over the summer. He said, you know what, Sandy, we should get married. She said no. Can you imagine proposing to someone by letter? I mean, it's nicer than like a tweet or like a text or something, but you know.
But wasn't she still at Stanford and he was at DC?
Yeah, he was clerking for the Supreme Court. And he said, we should get married this summer. So apparently she turned down a lot of suitors. Not justice suitors, that would have been crazy. But a lot, oh, man, she turned down a lot of male suitors. That's good, actually. She turned them all down, and she found John O'Connor she fell in love with, and that the rest is history. But can you imagine? Rehnquist proposed to her, and then they had to work together. Awkward. Can you imagine? Girl turned him down, and they had to work together for 20-something years. Man, but apparently, and this was in the NPR piece, apparently, I didn't know this, Rehnquist recommended to Reagan to look at O'Connor for the court. Maybe get another go at it, right? Well, but anyway, I think it's a nice story. I think it's a nice story. I didn't know that. In fact, this was only found recently. O'Connor's kids didn't even know this. It was found in some of her letters in her archives. Someone's writing a biography about her. A beautiful story. It's an NPR. Go listen to Nina Thornberger. Usually I know this stuff. This I did not know. Also, one other factoid. I said something that she could only get a job as a secretary. So the actual story, I found this today also, she was offered a job as a secretary. She declined it. And then she told the local prosecutor in Arizona, I'll work for free. And apparently said, I have nowhere to put you. So then she said, I'll put a desk over here. And then if she worked for free, then eventually he hired her. So there's a upshot. But yeah, she turned down Rehnquist. He was a Supreme Court clerk also. That's it, to turn that down. He was clerking for Jackson.
Wow.
Turning that guy, I mean, she was, yeah. She had her way, yeah. One of her clerks said he tweeted that she was bossy from the get-go. She was in charge from the get-go. I mean, that's pretty remarkable, right? She was one of three or four females at the entire Stanford Law School. One, 3 or 4. And basically you have a Supreme Court clerk proposing to her by letter. And she's like, nah, never mind. That was, I mean, for the time, that's pretty remarkable. It's a what move? It's a boss move, I'll give you that. All right. Yeah, Michelle, you're covered by cupcakes. Michelle, you wanna give me, your name is Boo at the moment, that's what the name is. Yeah.
Are you about to move on to the case?
Yeah, I'm doing.
I have a question though.
Please.
I thought that, in my notes might be wrong, I thought that you said that the state, for the second trimester, in Roe v. Wade, that the state had a strong interest in the mother's health and fetal life, but it just wasn't strong enough
To protect it.
Okay.
Yeah, that was the rub from Justice Blackmun. Thank you for clarifying that, Monique. Yeah, that was the rub. He says, of course the state has an interest in prenatal life, but it's not strong enough of an interest to justify restriction on the mother's life. Maybe I can phrase that question more precisely. Yeah, thank you. I'll keep that in mind for next year. Yeah. You want to give me the facts and Bowers, please?
Yes.
Let's resume law.
So Hardwick was charged with sodomy, and so the district attorney decided not to, pursue the charge unless they had further evidence. But before doing so, Hardwick brought this into federal court and basically challenged the constitutionality of the joint statute.
Good.
And so he also, I guess, gave the information that he was a practicing homosexual, which was a large basis of the majority opinion. And so basically what he says is that the statute placed him in imminent danger of being arrested, violates the Constitution. And so the district court ended up granting the motion to dismiss, but then the Court of Appeals reversed it based on, they said, based on Griswold and Roe v. Wade. And basically what they said is that homosexual activity is a private and intimate association beyond the reach of the state.
Okay, very good. Thank you so much for those excellent facts. So this is one of those cases that only comes around by bizarre circumstances. At the time in the 1960s and 70s, the majority of states had laws prohibiting sodomy, right? And sodomy is defined broadly, and the statute gives it, contact between the anus and mouth and genitalia. I'll leave it there, okay? You're welcome. Some states made it only sodomy between people of the same sex. That was Texas, right? Texas's statute only prohibited sodomy between two people of the same sex. Georgia, in contrast, prohibited it even with heterosexual couples, which actually makes a difference when we get to Lawrence in the next class. Even though almost all of these states had such laws on the books, they were not enforced for a very obvious reason. Usually when people engage in these acts, the police aren't there. And usually when these people engage in these acts, it's consensual. And the other person's not going to run to the cops and say this person did whatever. Now, there are cases where it's not consensual, right? That happens. And those cases are prosecuted, right? I don't need to go into details, but those cases do tend to be prosecuted if it's non-consensual. But if it's consensual, usually it's only two people there, maybe two or more, but they're there willingly. So in this case, it was, again, a bizarre circumstance. So Michael Hardwick failed to appear in court. He had been, I think, charged with drunk driving, something trivial. The cops come to his house to pick him up. The roommate let him into the house. It's only the roommate's fault, right? And the police searched Hardwick's house, and they noticed the door was partly open. And they walked in, and they saw Hardwick engaging in oral sex with another guy. Then they were both arrested and charged with a crime. So the fact that this even happened was due to some fluke accident where the cops walked in at the exact moment they were getting on with these facts were going on. Okay, I'll just give you a preview in Lawrence against Texas. Is that for Monday? I think it's Monday. The facts are similarly weird. You have Lawrence and Garner, right? They were having a relationship. Garner's boyfriend was jealous that he was with Lawrence. Garner's boyfriend called the cops on Lawrence and said, there's a guy in there with a gun. So that way the cops showed up at Lawrence and Garner's apartment, and then they saw what they saw. Now, what they saw actually is controversial, and I had this in the video, but we cut it out probably as a good idea. One of the cops in the Lawrence case said he saw anal sex. One of the cops said he saw oral sex, and the other two said they saw nothing. You can't confuse the two acts. You can't. I'm sorry. So they arrested him on the charges of sodomy. By the way, this was Randy's video. It's like, I'm not reading. So I'm like, okay, fine. So we cut out of the script. But the point is, these sorts of cases are rare. And the reason why they're rare is they just don't happen that police see this stuff. It doesn't happen very often when it's consensual. So Bowers was it 1988, 89? I'm sorry, 86. I'm sorry by 2 years. Yeah, 86. So very good recitation of the facts. Kanisha, I think, did I do this row? Am I going this way or? Are you next?
You went that way and then you came over here.
Why were you next? Me. Who's next? Just raise your hand. Whoever's next.
So what you did was you went there and then you went up here.
Okay, I'm gonna go here. Harden. Okay. So what did describe for me Justice White's approach right? Just Sergio, describe for Justice White's approach, right? How does Justice White approach this case? How did Justice White go about approaching this case?
He was talking about the liberties that are deeply rooted in the nation's history and tradition.
Well, what? Okay, so Sergio, let me take a step back here, right? What exactly does Bowers claim to be? I'm sorry. What exactly is Hardwick claiming that he has a right to do here?
He has a fundamental right to engage in homosexual sodomy.
Okay, and where does he think he gets this right from?
Well, he was claiming it from the right to privacy.
Okay, and what provision of the Constitution is that protected by?
14th Amendment.
Okay, 14th Amendment, right? Now, does the 14th Amendment say anything at all about sodomy or sex or any of that stuff?
No.
So what provision of the 14th Amendment is he relying on? What clause is he relying on?
Process clause.
And specifically, what word in the due process clause?
Liberty.
Liberty, right? So we're dealing here with the phrase liberty in the 14th Amendment, right? The word liberty in the 14th Amendment. The word liberty is not defined. And at various points in the court's history, they've defined liberty in different fashions. Think of Lochner. The court said that word liberty means the liberty of contract, or some sort of property right. Think of Loving, right? That the word liberty means you have the right to choose who you marry. In Myers and Pierce, it involved education, right? The right to educate your children. And then in Griswold, with the penumbras, you have a right of privacy. And then in Roe, you have a right to an abortion, right? Chris, let me ask you this question. How is a judge, or how does Justice White think a judge is supposed to decide the meaning of the word liberty in the 14th Amendment? What should a judge go on? I mean, how is a judge to approach that task?
Kind of based on like the nation.
I'm fine. Yeah, I'm fine. Went down the wrong pipe.
Based on like history and tradition, kind of like is how things.
Okay,
have
good.
gone.
History and tradition. Okay, let me ask you a follow-up, Kristen. Why does Justice White think it's important to limit protection of unenumerated rights to history and tradition? Why is that important for him?
I'm trying to. Because it goes along with like morality. It keeps the laws aligned and keep people moral.
Let me ask you another question. I'll ask the question differently. What's the risk if the courts aren't guided by history and tradition? What's the risk?
The people will just kind of start doing whatever.
Well, is the people or judges? Who are we talking about here?
Oh, well, that the judges will just kind of say that everything is a right.
Making stuff up. Yeah, there we go. Thank you so much. Right, so here's the risk, right? Justice White says, if we allow judges to identify liberty in any way they see fit, it's a free-for-all, right? There's no boundaries, there's no guidelines, there's no guardrails to keep the court within some sort of normalcy. And he references Lochner. It keeps going back to Lochner, right? You can never escape that case, no matter how hard you try. Lochner and Lee Optical, you cannot escape those cases. They always come back to haunt you, right? Happy Halloween, right? If judges are not guided by history and tradition, then they're just making stuff up. So then he says, okay, so judges can recognize unenumerated rights and declare them fundamental if they are deeply rooted in our nation's history and traditions. Okay, so Marcus, what does Justice White think about a right to sodomy? Is that right deeply rooted in our nation's histories and traditions?
It says the Constitution, he feels the Constitution does not provide a fundamental right to engage in homosexuality.
Well, just answer my question, right? Does he think it's deeply rooted in history and tradition? We'll get to the fundamental part in a minute.
No.
Why not? How does he get there?
He says it's not supported by the text of the Constitution.
Well, of course it's not in the text, right? That's easy, because it just says liberty. Liberty doesn't tell you a damn thing. But how do you know if it's deeply rooted in the text and history of the Constitution?
Going to this bit about obscene material and a person's privacy.
Okay, all right. Jason, what do you think, right? How does Justice White know that this right to sodomy is not deeply rooted in history?
How does he know?
Yeah, how does he know? Yeah. What does he look to? OMG. Someone just took a Constitution. Ah! Look at this. Look at this. Look at her hand. She's got a Constitution. Look at that. Look, he's handing her a Constitution. Oh! I'm going to cry. I'm going to cry. I'm going to cry. I'm going to cry. That's just awesome. All right. The Halloween camp. That was so cute. Jason, let's go something less cute. Jason, how does Justice White know that the right to sodomy is not deeply rooted in our nation's history and traditions?
He goes back to some decisions.
Okay. Specifically, what's very good evidence that this right is not deeply rooted? There's very good evidence, very obvious evidence. Drew?
Yeah, he went back in history and showed all the laws that were charging sodomy as a criminal offense.
How many states had them?
At present day it was 24, but in 1961 all 50 had them.
Okay. That's what I'm looking for, right? So Justice White says this. How can you claim that the Constitution protects a right to do X when X has been illegal in all 50 states for a very long time? Right? If you start with the fundamental rights approach, right, and you look to history, then you got a problem. It only permits old rights that have fallen out of favor, but not new rights that have not been accepted. Now, I don't want to dwell too much on Bowers, because again, it was overruled. But in the Lawrence decision, Justice Kennedy basically says, we're not limited to history and tradition, right? He abandons the fundamental rights approach in Bowers. Now, as a historical matter, Chief Justice Berger writes his concurring opinion, where he does a survey of history. Now, the history there isn't all good. And let me just make this point briefly. It's not critical, but let me make the point briefly. The sodomy prosecutions that existed were generally of a predatory nature, right? Non-consensual. That there wasn't a long history of prosecuting consensual sodomy. That the thing that was actually being prohibited was predatory, non-consensual. So to the extent that they're looking at history, it's not clear that their history was accurate. But even so, right? Even so, does the fact that something was legal yesterday mean it's a right tomorrow? Who asked me this? Was it Adrian? Did you ask me this question the other day? You asked me this question, I think, the other day. I told you this. Something similar.
I think
you did.
after class.
Yeah, after class. Adrian asked me this, and I thought it was a very good question. So let me bring it back into the fold. The fact that something was legal yesterday, does that mean the government can never criminalize it? Does that mean that once something's legal today, it will forever be a right? Okay. So the fact that they only criminalize certain acts, in my mind, doesn't settle the fact. Yeah?
Just because it's illegal doesn't mean it's not a right, though.
If you have a right to do something, can the state criminalize it?
The state can criminalize it, but it doesn't necessarily mean that it's not a fundamental.
But if you have a right to do it, they can't criminalize it. That's the entire point of the due process framework, right? If you have a right to do X, then they can't.
If the state's interest is substantial enough, then at any point the state can infringe on your rights.
When you're in strict scrutiny land, virtually no state interest is compelling enough to stop it. If the right's fundamental. What?
That's not what Korematsu says.
Korematsu, yeah. That's why the case is generally not cited very much. But it's a very good point. Very, yeah, it's a good point. Korematsu, again, is a tough case. Actually, Korematsu, there are a lot to say about Korematsu, but as a general matter, laws restricting a right have to have a very heavy burden, a very compelling interest. But the general point If some act was lawful 100 years ago, can the state now decide, no, you know what, we've decided to ban this because it's it was a mistake to leave this legal, or maybe we lack the resources to criminalize it. Okay. The second point I want to discuss about Bowers is a topic we'll keep coming back to, and that topic is called moral disapproval. Okay? Moral disapproval. Now, much of our laws, right, are premised on the notion that you can't do this because you're harming someone else, right? I think we would all agree that murder is bad, right? You're harming someone else. I think everyone would agree that a battery is a bad idea because you're harming someone else, right? Theft is a bad idea because you're taking someone's property. Trespass because you're going onto their land, right? Where there's a physical harm to someone else. But what if the harm isn't to someone else, but someone's doing something that doesn't harm them and doesn't directly harm anyone else? Can the state say, okay, we get it, you're not harming anyone, but we want to stop you from doing what you're doing because we think it's immoral? Because under the police power, it's health, safety, welfare, and public morals. And what if they say that the harm of you doing this isn't to yourself or to the person you're with, but to the community as a whole, because it promotes some form of immorality that we find improper, however defined. Historically, we have lots of those laws. Prostitution is probably a classic example, right? If a person consensually wants to have sex and sell money for it, they can't do it. Drugs and alcohol abuse, right? If you want to put a product in your body that makes you go loopy or whatever else, can you do it? The state actually assumes, no, we will not let you put this product in your body because we know better. And think of Griswold, right? The state said we want to prevent you from using contraception to, I don't know, prevent adultery, whatever the interest was. But even in Griswold, the court said we uphold laws concerning adultery, what was Frank Sinatra's thing? Seduction, right? Alienation of affection. I think Kenesha made that point in the class the other day, right? How can the state justify making a law telling you can't do something because it's immoral? And Bowers adopts the frame that moral disapproval, merely saying something's immoral, is a rational basis on which a state can act. And nothing more than nothing more than moral disapproval is enough to support these laws. Yeah? I can't hear.
You said something said that and I missed you.
Bowers.
Oh, okay.
Bowers. Okay? Chance for your hand up?
No, I'm just shaking my head because then you have to question what is liberty.
What is liberty?
You have to question that then. And it becomes, didn't you say one of the justices, I think last week, one of the cases where you said he used divorce like several times.
Douglas.
Right? Well, somebody could look at that and say that that's immoral, so it's.
Oh, yeah. Justice Douglas was almost impeached a couple times.
So it's very subjective to use.
Right.
And that's all they use in this case is
Liberty.
moral judgment. I think in the dissent, Blackmun and Brennan, actually the dissent, we had more like legal analysis, because this was purely based on morality.
Well, you have to remember, and I want to make this point, right? When you're in rational basis mode, right, the bottom line is one of deference. And it's saying, because this is not a fundamental right, it's not our place to second guess the legislature. And if they come here and tell us that the basis of this law is morality, that's where our inquiry stops. Now, I think they also agree with that as a policy matter. I think that shows in their opinion strongly. One note, and I'll get to you in a second, I promise. Justice Powell, who is one of the judges in the majority here, was over from the swing vote. You know Powell from the affirmative action case, Bakke. He apparently told his clerks that term. He said, I'm paraphrasing, I don't think I've ever met a gay person. And one of his clerks' term was gay.
Yeah, you had that in the.
Yeah, I mentioned that thing, yeah. So the 1986, whatever year was, I think, a very different time then I think in years will come. Be a chance. Go ahead.
So Rehnquist was on the court at this time, right? Correct? It was 86.
Spurned by O'Connor. Yeah, he was on the court. She dissented. That's good.
But anyway, he used the rational
Let her talk, please. Yeah.
And his previous dissent, from last week. When we did last week.
Yeah,
So just based on what you're saying, he should have dissented here.
Rehnquist?
Yes, he should have, because if it's a rational basis analysis that he's using, that level of scrutiny, then a deference, there should be no law. I mean, he should be with he shouldn't be out saying that it's immoral. I mean.
But he's not. What he's saying is, I defer to the judgment of the state that's immoral. That's what deference means.
But, oh my God, you could totally rationalize any type of.
But that's the point of rational. But that's the point of rational basis review, right? If you presume that this is an area where the legislature has autonomy, then you defer to their judgment of what morality is, right? It's not the court saying. Berger, I think, maybe does say this, but the majority is not saying that we're deciding that this is immoral or not. He's simply saying that we're going to defer to the judgment of the legislature, the elected branches. I think they even noted some states repealed their sodomy statutes, right? So perhaps if there's a change, it's to come from the democratic process. That's other hands.
In your recording, you asked.
From last year?
Yeah, why this wasn't an equal protection.
Yeah. Do you want to answer?
I was actually going to ask are they able to say, like when they bring this, are they able to say that this should be an equal protection issue?
Well, this case was litigated in a strange fashion. And if you notice, they say there's certain arguments that were abandoned, right? Like there was a Ninth Amendment and stuff. Yeah, I don't know why this case was litigated the way it was. And I don't have an answer for you. I don't know what I said last year. Did I not answer it? I don't remember what I said. Yeah, Tim, you know what I said better than I do.
I was going to say the sodomy statute in question in Georgia applied to both heterosexual and homosexual couples.
Yeah.
It didn't matter. So
Right.
bring it as an equal protection
But was
matter.
it being applied equally? Because in the book, it wasn't clear in the case when they were describing it that it was being.
It doesn't.
Guys, just one time. So yeah, I think let me just summarize. So I think the short answer is, to the extent the statute was being enforced, it wasn't being enforced against straight people.
Yeah. So isn't that?
And I think that would probably be the law is not being protected and enforced equally. I do think that would be a case. But again, I don't want to make too many judgments because this case was not litigated in the smartest of ways. In fact, after this case, the LGBT movement started to get their act together and figure out a strategy of litigation that was much more sophisticated. This was basically argued because some guy got charged and it happened. And this resulted in a focus of how to litigate these cases in a smarter fashion. Other hands. All right. So I think Janice already mentioned the dissent by Justice Blackmun. I'll mention it briefly, but Justice Blackmun argues that this case isn't about a right to homosexual sodomy, that they're defining the right too narrowly, that it's more generally about a right to privacy and maybe a right to be let alone. I think Mia used that phrase in class last week, or last class, and to the extent that you have a what do you call it? Spatial, decisional and spatial aspects of the right to privacy. I still don't know what that means, but you have these zones of privacy, and the state can't intrude it. So the same zone of privacy that guarantees a woman's right to an abortion extends then to a zone of privacy to have sex with whomever you wish, and that's Justice Blackmun's dissent. Yeah, this was a very divisive case. In fact, Justice O'Connor joined the Bowers majority. And then 20 years later in Lawrence, or I guess about 17 years later in Lawrence, she joined the majority also, but she did not vote to overturn Bowers. O'Connor stood by her decision in Bowers, said the Texas statute's different because it only applies to same-sex couples, not opposite-sex couples. So O'Connor sort of reaffirmed Bowers till the end. Okay. I want to have plenty of time for Casey, and perhaps we have too much time at the outset on birthright, but any other questions on Bowers? Anything else on Bowers? Okay, so let's move on to Casey. Very important case, very important case. Abortion in the 1970s, early 70s, was not the same issue that it was today. It wasn't. It only became super contentious in the years following Roe. Indeed, Yarn. Please.
In the dissenting opinion for Justice Stevens,
Yeah.
it says, more talking about grade school, the protection for the children by unmarried people as well as married persons. Did we just
God.
read the case?
Sorry. I'm sorry. Repeat your question. I lost my thing.
In the dissenting opinion, he talks about the protection extends to the intimate choices by unmarried as well as married persons, talking about what is it, the right to contraception. Contraception, yeah.
Yeah.
So we just didn't read the case where they made it both to unmarried people and married people?
Yeah,
Or
that
it's just-
that was Eisenstadt v. Baird.
Okay.
That was one I spelled for college. I spelled correctly the other day. Yeah, yeah, that's Eisenstadt. Which maybe I should assign. I don't know. You have enough to read. I don't know. Oh, whenever I say that, it's like next year. Screw the one else, right? Yeah. Okay, so after Roe, there was a serious backlash to the decision. And among conservatives, especially in the evangelical community, there was a strong desire to see Roe overturned. It's still here 40 years later. And they recognized that an amendment to the Constitution was not probable. So the easiest way to overturn Roe was to add more conservative judges to the court. Still nothing changes, right? It's still there 40 years later. Now, in the 1980s and 1990s, you had 5 new justices appointed to the court. You had Justice O'Connor, you had Justice Scalia, and you had Justice Kennedy, and then you had Justice Souter, and you had Justice Thomas. 5 new members to the court were added in the span of 8 years. By the time you get to Casey in 92, you had 8 Republican appointments in the Supreme Court. 8. That's a lot. You had 1 Democratic appointment, which was Justice White. And if you recall, Justice White had dissented in Roe. So it wasn't looking too good. And then we get to Casey. And Casey's argued. And after it was argued, it was a 5-vote block to overrule Roe in its entirety. Basically, you give rational basis review to abortion laws. Right? It's not that they could criminalize it. That wouldn't happen. But you go back to a regime where it's only a rational basis review. And then we had a compromise of sorts where Justice Kennedy changed his mind. And he was persuaded to join a joint opinion, which he wrote part of, with Justices O'Connor and Souter. And what that opinion did, we'll spend a lot of time discussing, but it did something, right? So, Kanisha, why don't you just give me the general facts and introduce Casey, please? Yeah.
That's a little confusing. So he changed his mind. They hadn't issued the opinion yet.
No, it was after the conference. So the way it works, this is like Obamacare, right? Like John Roberts sort of changed his mind after the case was argued. So the way it usually works, one second, I'll come back to you, is that a case is argued, and on the Friday after all arguments, the justices vote. It's their tradition. They don't talk about a case before it's argued. They're not supposed to. They often do. And they have a vote in conference. And based on the conference vote, someone's assigned a majority opinion. But it doesn't always stay that way. And very often, things move. A majority might become a dissent. And if a dissent's persuasive enough, it might become a majority. Right? The justices do change their minds. It's not common. But in a case like this, right, where this was an issue that's been known for 20 years, it was a big deal for Kennedy to swap. So Kanisha, you want to just give me the background and facts in Casey, please? Thank you.
Okay, so there was an issue with provisions in the Pennsylvania Abortion Control Act of '82.
Yeah.
And that act required that women seeking an abortion had to give, that a woman seeking an abortion had to give informed consent prior to the abortion procedure, specifics associated with that. And then there were things, for a minor to get an abortion, the act required that they had to have consent from the parents. And they had another provision in the act that unless there were certain exceptions that applied, a married woman that was seeking an abortion had to indicate that her husband was cool with it. And then the act exempted compliance with those requirements if there was like a medical emergency. So before the provisions of the act went into effect, there were the petitioners who were Casey. They were, no, it wasn't, I'm sorry, that was the clinic. So it was the clinic's Planned Parenthood, and then there was a physician who was representing himself, and they were bringing suit for injunctive on the provision saying that it was unconstitutional.
Okay, very good. Oh, keep going, keep going. You'll stop. You know, the number one rule of being an attorney is knowing when to stop. I was arguing with Case over the summer, and I was up there for a couple minutes, and I sensed, wow, this judge is not asking me any questions. I said, okay, Your Honor, no further questions. I'm going to sit down. I had like 20 minutes. I used maybe 5, because you might say something that hurts you. So, all right, Your Honor, I'm done, and I won. So, but yeah, so always know when to stop. Occasionally at the Supreme Court, if you're really good and they're not asking any questions, Your Honor, if no further questions, I'll sit down. That means you're a pro. That's a boss move. Okay, so the Pennsylvania statute came about. Use your phrase. You said boss move, right? Yeah, you said boss move. I learned from you. So the Pennsylvania statute came about in the context of the 1980s. And there were a number of decisions in the Supreme Court where several justices suggested that strict scrutiny should not be appropriate for abortion laws, that this is not a fundamental right, that it's only afforded rational basis review. And though we're not majority opinions, there were maybe 3, maybe even 4 justices who said that. Even O'Connor seemed to suggest that. But now you had new justices. You had Thomas and you had Souter, right, where the court had simply perhaps tilted more to the right. So states became more bold in enacting these sorts of laws. And it comes to Casey. So the most controversial of the Pennsylvania laws, there were several, I think 4 of them. Was it 4 or 5? I always forget. But the most controversial of the Pennsylvania laws was that if you were a married woman seeking an abortion, you were required to sign a statement stating that you told your husband about the abortion. It's not that you had to get his permission, but you had to certify you told him about it. Minors had to obtain consent from a parent, but there's what's called a judicial bypass. They can go to court if the parent won't give the consent. There was also a 24-hour waiting period for an abortion. And also, the doctors were required to give some sort of information as a form of informed consent. Okay? Ultimately, the court upheld everything, not the court, but the plurality upheld everything except for the husband provision. All right, so now let's take a step back. All right, the first word in the opinion, or the first sentence in the opinion. Who's next? Yeah, Kyle. The first sentence in the opinion is this: liberty finds no refuge in a jurisprudence of doubt. What does that mean, Kyle?
It's doubtful.
Doubtful. Doubt fire, maybe. But what does that mean? You got to give me something.
So based on the sentence that follows it, is that she wants the jurisprudence to be clear, right? So that there is no doubt as to what it grants or doesn't grant, like what the rule of.
Well, but it's not she, it's they, right? It's O'Connor, Souter, and Kennedy. It's a joint opinion, right? There was no majority in Casey, but the 3 of them have the controlling opinion why it's the most narrow decision, right? That's the so-called Marx rule or something like that, right? It's the most narrow decision. But O'Connor says liberty finds, they say, liberty finds a refuge in a jurisprudence of doubt. What's a jurisprudence of doubt?
I understand it to be one that's not certain, like an uncertainly expressed rule.
And why can't liberty exist if you have a doubtful jurisprudence?
Because you don't know what your right is, so you don't know if you are subject to arrest. Go back to Bowers.
Ross, what does that mean, liberty finds a refuge in a jurisprudence of doubt?
Job is to define liberty for all, not for the moral code. Kind of thinking about maybe how you were talking about in the previous case, how they're trying not to just base it on whatever, make it up, have something.
Well, so would you describe Roe as a jurisprudence of doubt? Just is Griswold a jurisprudence of doubt, where they're just making up penumbras?
I guess they all are. In a way.
Jessica, what is a jurisprudence of doubt? I'm dwelling on this for a minute. I promise there's a reason. What's a jurisprudence of doubt?
I mean, I was thinking of the same thing that Kyle is, that where you don't know, it's uncertain, so that's why the court is.
So then if a jurisprudence of doubt is a bad thing, what should the court strive for? What should the court try to achieve then? If jurisprudence of doubt's bad, what's good? What's good for liberty?
I guess like an agreement on what is defined as liberty and what is not, like I guess, I don't know, that's hard.
Now you're on the right track. You get a little
Like,
more.
Liberty versus like the fundamental rights, they talked about that.
But if it's bad, if doubt is bad for liberty, what's good for liberty, according to the plurality?
I guess like an agreement, like if
Agreement between whom?
the justices on what
On what?
the issue is, like what liberty is.
Okay, and what if some judges don't agree on that?
I guess in the majority of them that do.
Jesse, what do you think?
I have no idea.
Glennis?
Like.
How do you get out of that?
I have.
You can come back with another question.
I'll come back. Glennis, what do you think?
Like having clarity around it.
Clarity. Okay, what do you mean?
So, I guess kind of like what Jessica was saying, like being like more clear about exactly what.
Clear to whom?
To the like people.
People. That's it, right? It's not just about clarity among the judges, right, or agreement among the judges. It's about clarity, or you maybe say certainty, predictability, right? Stability. That the law is stable, that people know what to expect. And what the court's getting at is that when things are uncertain, in flux, unstable, they can't know what's good for them. I'm sorry, Adrian? The people can't know. Right. So the crux of this, right? And hold on, I think I have the picture here. Ooh, crap. Sorry if I knock it over. I don't have it here, sorry. The New York Times, the day after Roe, the headline, I'm paraphrasing, said, Supreme Court upholds Roe v. Wade. That's what this New York Times said, front page. Supreme Court upholds Roe v. Wade. Now, I don't think that's a fair characterization the court's holding, but if you want to summarize the case in 5 or 6 words, which the newspaper headline does, it's pretty damn accurate. So if you're a person, right, and you just see the Casey headline, oh, I guess Roe v. Wade was upheld, whatever. That's not doubt. That's certainty. That's stability. That's predictability, right? So the crux of the opinion is, even if Roe was incorrect as an original matter, even if they would not have joined Roe were they on the court in 1972, stare decisis compels them not to overturn it. One second. Now, they said that. If they actually did that and upheld Roe, it would be a different story. But they didn't actually do it. They basically gutted the decision. They killed like 8 parts of it. Right. But what matters is for people, not lawyers, not smart attorneys and law students like you all. No, you are smart. I think you're all very intelligent, right? By the way, you did well in the midterm. I mean that sincerely. You guys did pretty well as a whole, as a class. I was impressed. What?
Nothing. It was hard.
No, but you did well. You did better than usual. I was expecting worse, so you exceeded my expectations. You exceeded my expectations. It's good. They were based on past semesters. You did well. You did well. So. But my point here is, if you're not a smart law student or a smart attorney and you just see the headline in the New York Times, Roe upheld, it's like, oh, okay, move on like normal. Everything stays the same. So the difficulty for a lot of law students, and maybe you share this, is saying, okay, we are reaffirming Roe, we're upholding Roe, except we're doing 8 million things to it and chopping it apart, right? Get rid of this part, and get rid of this part, and get rid of this part, and get rid of this part, right? So what's going on here, right? It's a version of stare decisis. I think Scalia makes his point. He's very angry here. He usually is. He's angry the rest of the semester. I don't think you have a Scalia majority for the rest of the semester. I think you only have Scalia dissents going forward, if I can count that correctly. But Scalia's point is this is not stare decisis because you are not actually upholding the decision as it's written, right? So putting stare decisis, any questions on the stare decisis aspect, right? Yeah, I'm sorry, I didn't call on you before, I apologize.
Oh, no, it's cool. So about the stare decisis thing, in the opinion, it didn't make sense because basically they were saying the people who relied on Roe v. Wade, if you overturned it, they would suddenly not be able to rely upon that. But that's the whole nature of overruling something. So I didn't understand if we know that because of history, and they kept talking about like Plessy versus Ferguson and how like there has to be some change, it has to be very compelling. But if you know that there is in your system of like doing things, there's a possibility that things can be overturned. It shouldn't be absolutely impossible.
Let me ask a provocative question, right? So the portion of the opinion discussing reliance says that women rely on this in their daily lives, that they structure their lives around it. Right? The idea is when a woman goes about doing her business, she knows that if something happens, she can fall back on Roe. Yeah. So provocative. Someone asked me this recently. I didn't thought of it. Let me ask a provocative question. What if the court said, okay, we will delay the impact of our decision for 9 months? So if anyone currently pregnant or about to get pregnant, will we rely on it? But going forward, people know that if they get pregnant, they can't rely on Roe. Provocative question, huh? 10 months, 11 months, whatever the number is, we'll delay it 1 year so people get notice.
That would alter their life, though, how they live their life.
Right.
Assuming that they do.
Right, but they have notice. But now they have notice. In other words, if you're currently pregnant for the next 10 months or 11 months, you can benefit from the decision, but not otherwise.
I think that would be, I think that's logical only because I just feel like if you know, whatever your opinion is going to be on this, or the court's opinion is going to be, let it be the opinion, but the logic that you give behind it, that when you overturn something, it's going to affect the people who relied on it, well, that's common sense. Anytime you overturn something, it's going to affect people who relied on it, if it's big enough. So I don't understand, I just thought it was really, really shallow logic. If that makes sense.
I saw Jesse and I saw Janice. I don't know who was first.
I'm playing with my hair.
Oh, you play with your hair? Okay, I'm sorry. Yeah, okay, Jesse, redeem, yeah.
No, I'm not redeeming. I'm ultimately this is redemption. Your video's offline right now, just so you know.
My
If you're watching, you can't see.
I'm streaming. The light's on.
It's not. The answer is not.
It's streaming. I'm online. I'm live. Josh is live.
Okay, so Josh, go back to your question.
Yeah.
When you're back.
It's live. I'm watching it. Here. Go Meta. It's live. Yeah, I'll be there in a second. It's on a slight delay. Happy Halloween. Okay. Okay. All right.
So go back to your question.
Yeah.
What would be the purpose if the Supreme Court makes that decision, and they're making that decision because that's the law, that's the law, or whether it's in the Constitution, whatever, for whatever reason they came up with the decision, what would be the purpose for delaying the law? I mean, outside of
It's meant as a hypothetical, purely hypothetical reason about reliance. It's not a real question. I don't mean it to be an actual thing. Kyle and Mia.
I can answer. So the reason is
This way. Yeah.
Oh. But anyway, so the reason is that according to the opinion, women are relying on the fact that they're able to get an abortion. So a woman is not a woman. All the women who are pregnant at the time that this opinion was issued, well, their frame for having an abortion is gone. So 9 months later, they can't make that argument.
I think that makes sense.
That's the point, right? They have notice.
Right. So the plurality, let me address, maybe I'll call them people. The plurality basically seems to suggest that it's not just about the decision of people currently pregnant. but people structure their lives that maybe they pursue certain options or don't pursue certain options premise on the knowledge you can fall back on this case. So the provocative question doesn't get you all the way, I don't think. But anyway, someone asked me this recently. I hadn't considered it, so I only put it out there because I had never thought about it.
But it basically says this can never be, oh, sorry.
Yeah, go ahead.
It basically says this can never, that what this is saying is that Roe v. Wade can never be overruled. That's what this is saying.
Yes, right. So the upshot is that there are certain cases that are so important, that are so relied upon, that have ingrained themselves, even if they're wrong as an original matter, will not be overturned.
Only it was. Only certain cases. But if you, to not overturn, I don't so it certain cases won't be partially overturned, is what they mean.
Well,
Because
yeah.
I agree. Shocked that I agree with
Scalia,
You know what? You've been in my class too long.
Well, I mean, logic is right. So logically, if you're following, based on stare decisis, if you are going to follow the decision of that case, right? I mean, I thought that's what it meant. So you can't mostly overrule it and then overturn it and then say this.
Yeah.
And that's what happened. It's like another one of those, let me justify what I'm doing, but not really, and kind of change the definition of something as I go along because it works for what I
Yeah. Let me summarize a bit and just bring together several thoughts that are floating around. If the court actually meant what it said and said because Roe is so important you can't overturn it, they would not have overturned part of it, right? And let me just, and I'll summarize a bit, right? So Roe had several important points, right? Several key aspects of the framework, right? So the most important of which was the trimester approach, right? This was the crux of the opinion. In the first trimester, you have these sorts of rules, and the second trimester, you have these sorts of rules, and the third trimester, you have these sorts of rules. And then the court says here that this rigid approach is not necessary. Justice Kennedy says it's not necessary. Again, it's difficult to say that. And Justice Blackmun, who wrote the Roe decision, is really pissed. He's like, wait a minute, whoa. I thought we had a consensus here. This is an important case. You can't overturn it. So first they kill the trimester framework. Second, the court's decision in Roe described the right as fundamental, as part of a right to privacy. But Casey doesn't frame it as an aspect of privacy. It says this is just liberty. And he uses the phrase liberty very broadly. It says involving those intimate and personal choices a person can make. Oh, in this sentence, at the heart of liberty is the right to define one's own existence, of meaning of the universe, and of the mystery of human life. I don't know. This is peak Kennedy. I don't know what that means, but he's trying to get at this is very important liberty to people, right? Third, right, the Roe court was very clear that before viability, the state does not have a compelling enough interest in maternal life to protect, to regulate abortion, right? That the interest in prenatal life only kicks in after the third trimester. But Casey held that at all 9 months of the pregnancy, all 9 months, the state can regulate abortion to protect prenatal life, right? Justice Blackmun spent page by page saying why this is not the case, that until you have viability, it doesn't matter. But Casey said, no, the state can enact. This is why the 24-hour abortion law, the 24-hour notification law, applies all 9 months. The informed consent law in Pennsylvania applies the entire duration of pregnancy, right? It's not only the viability point. Roe said you can only do that after viability, right? Restrictions on abortion. Finally, this is the most important change. Roe applied what can only be called strict scrutiny. That's the only way you describe it. Casey says, no, this is not strict scrutiny. We apply this new test called the undue burden standard, right? That the state can't put a substantial obstacle in from a woman's right to access an abortion, right? That's different than saying, is this narrowly tailored to serve a compelling state interest, right? Narrow tailoring focuses on the government, right? Is this law as narrow as possible? Undue burden says, well, is this burden big enough for the woman, right? Is the burden too big or not? It shifts the focus, right? It shifts the focus is the government acting as narrowly as possible to how big is the burden they're putting from the woman to get to an abortion, right? You see the shift. It's a very different approach. So to Justice Scalia's point, and I think people might agree with him on this one at least, the court is saying one thing, or the plurality is saying one thing, and they're doing something completely different. And again, if you read the first page of the New York Times, Roe upheld, okay, great, Roe's upheld. But if you actually look at it, the world and abortion laws look very different after Casey. The sort of informed consent law that they upheld in Casey would not have survived Roe. The 24-hour waiting period that they upheld in Casey would not have survived Roe. I don't think it would have, especially not early on in the pregnancy. The only law that they struck down was the part about that you have to sign a thing saying that you told your husband about the abortion, right? That certainly would not have survived Roe, but it didn't survive Casey as well. So the court shifted a lot. And it upheld Roe in name only. So whenever you see people have signs saying save Roe, you see these bumper stickers, right? I say, no, save Casey. Casey's the name of the case that you have to talk about. Whenever I say that in the radio, it's like, we don't care about the name of the case, which is basically the point, right? No one actually cares about the doctrine. This issue is basically a yes or no, up or down issue. The actual nuances are irrelevant, which is why people who actually read the case are often surprised. Okay, I think I summarized enough of it. Any questions about the majority? I apologize, I have to go quickly when we have a fun discussion about princesses taking my constitution, which I love. Makes me very happy. But Mia, yeah.
The doctrinal resilience.
Doctrinal resilience.
They talked about Griswold, and then like that, there were two doctrines that were viable here, and then the other one was the personal autonomy, the dignity one.
Right.
So is that like the new one coming in through this case?
Yeah, I mean, this doctrinal resiliency, right, and these various these various tests. What they're trying to say is, has Roe stood the test of time, right? Has it endured for, was it 20-something years at this point, 19 years, 20 years, whatever it is. And the court says that, look, it's proven workable, right? But what proved workable, for all of Roe's defects, it was easy to apply. First trimester, these rules. Second trimester, these rules. Third trimester, these rules. You might like it, you might hate it, but it's easy. Everyone knew what the standard was, right? There was no doubt. But here, Casey introduces a new line. Not trimester, but viability. And before viability, you can impose an undue burden. After viability, you can ban it altogether. But what's the inherent difficulty here? Viability depends on the state of art science, right? Whatever was viable line in 1972 is different than viability in 1992, is different than viability in 2018. I don't even know. I always ask, what's the line now? 27 weeks, 28 weeks? I don't even know. You Google that. When I get in trouble whenever I give a number, but yeah, and I mean there are standards, right? There are standards, and care sometimes works, sometimes doesn't. I don't know, but by injecting this viability line into it, it created a lot of uncertainty. So the biggest irony, liberty finds no refuge in a jurisprudence of doubt. The entire thing's in doubt. The entire thing's in doubt. What is the line? What is an undue burden, right? No one knows, which is why the Women's Health case was so important, because then you got 5 votes to give a little clarity, which is why we're going to do that case in a minute. But let me tell you something, right? You know, the court, we have a new justice, Justice Kavanaugh. You know, will they overturn Roe? They don't need to. This is an important point. There's no reason to overturn Roe at all. None at all. The court can simply say that whatever new restrictions come out are not undue burdens. Or the court can say that the viability line moves up to 20 weeks. And they can ban it afterwards, right? So the compromise in Casey, the compromise here, just bought some time. And it works only so long as the justice applying it, his name is Tony Kennedy, is still in the court. And once Tony Kennedy's not in the court and someone else is using his test, you're in trouble. I'm going to repeat this several times. Justice Kennedy's opinions are very open-ended and fluffy, right? That's great when he's the 5th vote. But when he's not the fifth vote and someone else is, those tests cut the other way. So for all of Roe's defects, it was easy to apply, clear. 1, 2, 3, bang, 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 right? You know what the rule was. With Casey, you don't know. When you guys read Lawrence v. Texas next week, what's the test? I don't know. When you read a Bergefell, what's the test? I don't know. So now we're in this space with the undue burden test is being applied by people who are not going to agree with Kennedy, but they can keep the test in place. Okay? No, there's no stupid questions in this class.
Is this the Kennedy that we're talking about? Is this the one that just retired recently? Okay, just.
Yes, ma'am. Same Anthony Michael Kennedy, AMK. Not Anthony Michael Hall, Anthony Michael Kennedy. Yeah.
So is marriage a privilege or a right?
Oh God! Last time we do the marriage cases. We'll get there. I can only do one thing at a time. All right. The dissents. I mean, you have the dissent from Rehnquist, and you have the just briefly. Justice Blackmun has this thing about the light is fading. It's very dramatic. He's like, when I am replaced, my replacement, his name was it Stephen Breyer, will have to be asked about all this stuff. Give me a break. Yeah. He was very old at this point, and there's almost like a bitterness to it, right? It's like, I've been here, I worked my butt off for this cause, I wrote this opinion 20-something years ago, and now these conservative judges are going to kill it. Yeah, when you leave the court, things disappear. In fact, Justice O'Connor, after she resigned, expressed a lot of regret for resigning. She said that I kind of wish I was still there, because the court, she says, making a mess with all my other cases, right? The court, overturning stuff. Yeah.
When you get on the court, how are you?
Me? Wouldn't you like to know? I don't know. Well, I think it's a mistake to put law professors on the court as a general.
He does not want that on him.
No. I think no. I think as a general matter, and I've said this before, there's no surprises. The Roe precedent is so ingrained, I don't think it's going anywhere. What will change is how the test is applied, right? What will change is how the court applies it in a given circumstance. And if you have a standard called undue burden, how do you decide what burden's undue? What obstacle is substantial? That's pretty open-ended. And specifically, if your line is viability, what happens as technology improves and you can credibly say the viability line is 25 weeks, 24 weeks, whatever that number is, I don't know. And that would have a significant impact. All right, but I don't think the case is being overturned anytime soon. I think it's a myth if you think that's not how the Roberts Court operates. No, I believe that sincerely. I don't think it's. I get asked this all the time. You're not the first. Don't worry, and I'm always on tape. Yeah.
Do you think in the future, like science as far as genetic science, is going to change the way the court looks at this issue as well? As far as it's improving to where a lot of people know now, you can kind of tell what the baby is going to be. It's going to be male and female. It's going to what eye color it's going to have. Like that science is coming out to where you're going to know that pretty early on.
Mm-hmm.
Like, do you think that will affect eventually?
I don't know.
Like you have somebody saying, well, I don't want a girl.
Well, yeah. So I mean, one of the live questions is, can a state prohibit an abortion if it's done because you don't like the sex of the child? In some countries, like China, for example, it's almost obligatory that, not anymore perhaps, but at a time that there was a female, they would abort it. There's an Ohio law that said you can't abort you can have an abortion if the child's diagnosed with Down syndrome. These are very hard questions which Casey doesn't really answer. Right, the whole women's health case was somewhat at the margins, right? It was about the conditions of the facility themselves, not the actual circumstance you can perform it, right? What time period, et cetera. Some states have enacted prohibitions on abortion once you have a heartbeat, which can be at 20-odd weeks. Yeah. There are different standards that have been about. All right, okay, Mia.
So do we talk about privacy any more after this, or is like privacy?
Privacy was a big thing in the 60s and 70s, and Kennedy likes liberty. Now, what's the difference between privacy and liberty? Not a whole lot. But Kennedy was very big on talking about liberty and freedom. That was his thing. He doesn't talk about privacy the same way they did in Roe and Griswold.
So they're still good, they just aren't, the language.
So you remember with the Commerce Clause, I could draw this really nice graph to plot things. I can't do that for due process. It's a mess. I tried, I made one, but it's very hard because for the last 30 years, Anthony Kennedy decided what liberty was, and now he's not in the court anymore.
So those privacy interests in those other cases, would they be classified as like a laundry list of liberties now? Or?
Probably, yeah. But again, it's very hard to bridge the gap in due process from the 50s to 60s to 70s to 90s. You can't draw a straight line the same way I could with the Commerce Clause cases. I can draw a line from Lochner to about the 1950s, and after that it goes off kilter. I can even draw from Lochner to Lee Optical. I can do about that far. I made one of those graphs, but after that goes off the rails. All right, so let's talk about the dissents for a bit, right? There were 4 votes here to overturn Roe in its entirety, and that's awfully close. Had President George H.W. Bush not nominated David Souter, had he picked anyone else on the short list, Roe would have been overturned in the 90s. I think at that point, it's hard to predict what would have happened, but I think it would have overturned pretty quickly. Scalia is very, very angry here. And he usually is. He was on the dissenting end for almost all these cases while the rest of the term. And he criticizes the majority approach of stare decisis. And he refers to the imperial judiciary, one of my favorite phrases. He always said he wrote his dissent for law school case books. He even compares the majority opinion to Justice Taney in Dred Scott, and said the same way that Taney tried to settle the debate over abortion, the majority tries to do so here. And Scalia says this will not settle anything. What's that? I'm sorry. The same way that Taney tried to settle the slavery issue, thank you for correcting me, then Justice Scalia says the plurality here was trying to settle the abortion issue, and they didn't. And indeed, 30 years after Casey, they're still trying to overturn the damn case. So this issue has not settled. A lot of our cases, like the gay marriage decision, the backlash to that was pretty small. It faded pretty quick. It was, okay, gay marriage, whatever. It wasn't sort of sustained. But this case is different. I don't know why. Maybe you have better insights into the world. But 40 years later, this is still the hot button issue, right? This is the issue that people say, Supreme Court, yes or no. Gay marriage, whatever. Second Amendment, people move on. Voting rights, whatever. But this issue, right, stays in such a central portion that I don't know why, and it's ingrained in a way that I don't think any other issue in our polity has. You may have more wisdom than I do. I don't know why, but Scalia's right about this much. No case will end the dispute. And if in 5 years, a more conservative court says that Roe v. Wade gets pared back, it'll still be contentious, just on the other side. So this issue is not going anywhere. The courts cannot resolve this question, and I don't know their elected branches can do it either. Because you look at a state like California, which has basically public funding for abortion, and you look at a state like Texas, which has very difficult to get one in most places in the state. And there's just such a disparity in how these processes exist today. All right. Any other questions on Casey? And by the way, I put the scripts for Casey and Whole Woman's Health, and just read those. I'll summarize it because we had to move around a little quickly today. Okay. All right, Jess, I'll come back to you to redeem yourself. Yeah, you want to give me the facts, please? And I was short on time. That's why I skipped. I have a mental clock. I know exactly how much time I have left. So that's why I did. I didn't mean to. Jesse, you want to give me the facts from Whole Woman's Health, please? I'm sorry? Oh, wow, you're trading. Jesse, do you accept that deal? Markia, give me the facts on Whole Woman's Health. I'm running out of time. These kids with trick or treat. I'm going to the airport after this. Doesn't even matter. I'm not going home. But whatever. I live there. Yeah.
So this is a Texas case where, this came out of the state of Texas, where the state, of course, Texas of all states, passed 2 laws that basically governing abortion, and one of the, provisions
required that doctors who perform abortions have to have like admitting privileges to the hospital if they're doing the abortion.
Admitting privileges where?
At hospitals, well, no more than 30 miles from.
Right. It's not where the abortion is performed, but they have to have admitting privileges at a nearby hospital.
Right.
Okay. Good.
And so that was a problem because a lot of rural or like country doctors wouldn't be able to obtain such privileges. And then the second provision required that the centers where they did the abortions had to have ambulatory surgical center, or they had to be ambulatory surgical centers, and that was a costly requirement. And so the plaintiff in this case sued the state and claiming that the laws or the provisions were unconstitutional.
Okay, very good. Thank you, Markia. So this was it SB 4 or 5? I can't remember the number. SB 4 or 5. This was the famous Wendy Davis filibuster. You guys remember this from a couple years ago, 2012 or so? Was it? With the pink Mizunos, right? What people don't remember is she ran out the session, the legislative session, then the governor called a special session, they enacted it like the next day. So, it was a nice short-lived, PR thing, but the law was enacted eventually. The two major provisions, again, concerned admitting privileges. If you were a doctor performed abortion, you had to have privileges to go to a hospital. And the second one, that the facilities that provide the abortions must meet certain standards, what are called surgical centers, right? If you notice, the name of this case is not Planned Parenthood. The name of the case is Whole Woman's Health. In fact, Planned Parenthood, which has facilities in the big cities, if you're going 45 right there in Houston, they've got this humongous facility. That facility complied with the law. They had the surgical standards, and their doctors had admitting privileges. Same in Dallas, Austin, San Antonio, and a couple other cities. But there were smaller clinics, Whole Woman's Health, in various places. Now, the reason why these centers didn't have surgical standards is they didn't perform surgery, right? There are two general types of abortion, surgical and medical, right? Surgical requires some form of surgery where you're actually going in invasively doing stuff to the body. Medical is you take a pill. And usually the way it works is you take a pill, you go home, and then the abortion usually happens at some point in the future. If there are complications, you can call the 911, go to the emergency room. But the actual act of the abortion doesn't take place at the clinic. Okay. Now, Jesse, what was Texas's justification for why they had these laws?
For the protection of the mother during the abortion, if there was ever any problems, that they'd be able to have a hospital where they could immediately get them in.
Okay. Now, as a consequence of this law, what would happen to the various abortion clinics in smaller smaller cities around the state?
Well, they would have to be shut down because if they're not in the correct proximity, then they would have to.
Could they come into conformance?
They could move, yeah. But
No, not to move. Could you improve the facility to meet these standards?
Yeah.
And could the doctors get these privileges?
Yes.
In theory. It'd be expensive. And we know the consequence of this statute is that a number of clinics, roughly half around the state, shut down. Right? They closed. They couldn't stay open. Especially places like in the valley, like Brownsville, and out west by El Paso, they simply shut down. So the litigation over this was very complicated. Again, the two primary provisions were the admitting and the surgical standards. There were other provisions that were fairly boring. So, for example, the width of hallways, right? Is that hallways have to be a certain width, wide enough to fit a gurney, right, a stretcher down the hallway. And there were other sort of mundane standards, that smoke detectors, right? You have to have a smoke detector. Okay, who cares about that? But the two provisions that really were concerning were the admitting privileges and the surgical standards. I think Janice, you're next. Okay. So did the state? Okay. So under Casey, right? The question is, does a law impose a substantial burden on a woman's access to an abortion, right? How did the majority, Justice Breyer, apply that standard in our case?
I believe that was the balance of the test, the burden against the
Yeah, go on, tell me.
The burden versus the benefits versus the burden.
Okay, so when you were reading Casey, and we read this a few minutes ago, right? Did the court discuss whether the various laws provide any benefit? I don't think it did. No. But again, and I'll defend this in a minute, but the Casey opinion didn't really describe whether the law imposes a benefit. I mean, in other words, why do you need to make a woman wait 24 hours? Does that actually provide a benefit? Well, maybe it gives her some time to think about it. Is that a good reason? Maybe yes, maybe no. Why do you give informed consent? Well, maybe the woman might learn something. Is it good? Maybe yes, maybe no. But the court didn't really discuss that. The innovation of Holman's Health is that Justice Breyer says you consider not only the burden, the obstacles, but whether there are actually benefits behind it. In other words, if a burden has no benefits, the burden's even bigger. Think of it like a balancing, right? If you have all burden and no benefit, it's an even more substantial obstacle. So the important innovation in Holman's Health is that they work in the question of whether these provisions have a benefit. Now,
so is that like a play on the means and ends and such?
yeah, it's new. Yeah, it's not only whether there's an obstacle, but whether those obstacles impose any benefits. Right, but let me take a step back, right? So text says, aha, we have benefits, right? The benefit is that if a doctor has these privileges and there's something that goes wrong, he can more easily go to the hospital to treat the patient. There's a private relationship. And if there's these surgical standards, if something goes wrong, they can perform surgery right there. The key point here, though, is that the court says those benefits are not real. That, number one, the risk of having a surgery in a non-surgical center is zero, right? You're not performing surgery in a place that only dispenses medicine. You can't. You're not allowed to. And second, okay, maybe it's the case that if your doctor has privileges, it makes the transition to a hospital a little bit easier, but call 911. Someone else can help you out. So not only does the court say, are there benefits, but the court asks, are those benefits sufficient? They actually weigh those benefits. So this is straight up Breyer. You weigh the burdens and you weigh the benefits. The benefits, they say, are slight. The burdens are substantial. Therefore, it's unconstitutional, those two aspects of the law. Right? So where the law stands, at least in 2016, I don't know if that's still the case, right? Kennedy's not the fifth vote anymore. But where the law stands in 2016 is that the court has to weigh whether both the benefits and burdens are there. So it's effectively now strict scrutiny. I don't know that it can characterize Casey as strict scrutiny, but I think the Holman's Health approach is pretty strict scrutiny, right? Even where the government gives a justification grounded in health and safety, the court can say, no, that's not the real justification. The court doesn't go quite as far as Ginsburg in her concurrence, where she says, this is just about putting up obstacles and making abortion harder. Right? Ginsburg says that a little more bluntly. But the majority, Justice Breyer is more diplomatic, just hints at it. Right? So that's your standard now for Holman's Health and the abortion cases. One note, though, on severability, right? We learned in cases like NFIB, the Obamacare case, that generally the court tries to avoid declaring laws unconstitutional, right? They only invalidate as little as necessary. But Justice Breyer goes off and says, you know what? We're going to strike down the entire statute, right? Even things that say you have to put smoke detectors in, right? Even things that say you have to have wider hallways, because we don't have to force people to litigate each and every option. That's not the normal approach. This actually reminded me of Lochner whenever I read this, right? Remember in Lochner, they upheld the law saying that you can't have dogs on the floor near the ovens, right? And they upheld the law saying you have to have, no sleeping on the floor. But they struck down the hours law. But here they struck down not just the two major provisions, but the entire statute, which I think was a bridge too far. And Thomas gets a bit at this in his dissent about severability, as is, I think, Justice Alito. Okay, are there any questions about the Holman's Health majority opinion? Yeah, Mia, please.
So on the burdens, you can aggregate them all, and if the combined effect of the provision or whatever, even if one individual burden on its own.
Well, let me twist your question, right? For women in Houston, Dallas, San Antonio, and Austin, which is basically the majority of the population, there's basically no burden, right? Because their clinics are up to spec. And one of the arguments was, is this a burden on a single woman, not an unmarried woman, but one woman, or is it a burden on the women statewide, right? What's the denominator? And the court basically says that even if in the majority of Texas, 80 or 90% of the women have access to one of these clinics that meets the standard, it's still not enough. The Fifth Circuit said because the majority of women in Texas have access, there's not a burden, right? The burden's minimal. Actually, I did this math when this case was being argued. There are places in Texas you have to drive 2 hours to get to a Walmart, right? There's some pretty remote places, So having to drive X hours might be different. Now, what if you have a small state like New Hampshire or Maine or Vermont? You can drive across the state in 5 minutes, right? And there's one clinic in the state, right? Or say there were two and then you drop down to one. Would that matter? Or what happens if you have a clinic over the border in Mississippi and you have a clinic over the border in New Mexico? Can you rely on those clinics? The denominator of what your basis is for the harm, but the court somewhat is fuzzy on that question. Okay. Again, Texas is a fairly big state, and you do have this issue with these huge pockets where there's nothing for a long period. So any other questions on the Heller step, whole women's healthy Heller, whole women's health, and we're practicing woman's. It's M-A-N, not M-E-N, whole women's health versus Heller step on the majority.
You said it's unconstitutional if the burden. If the burden outweighs the benefits.
That's, I think, what Justice Breyer said. If you have when you have slight benefits and great burdens, then the law is unconstitutional. Okay. I want to talk briefly about the Thomas dissent. And this is a point that I think will resonate with some people who have been frustrated with this class. I don't know. I have a mind read. I'm clairvoyant, right? And Justice Thomas makes a number of points where he says the entire framework of our constitutional law is premised on courts deciding which rights are fundamental and which rights aren't. And at this point, it's merely an act of policy, right? That there's no actual law behind it. And he attacks the entire tier scrutiny system. He says we have these tiers of scrutiny, which are increasingly a meaningless formalism. And the court applies whatever standard it likes to any given case, and there's nothing to it. And if you think Thomas is wrong here, wait till you get to the Kennedy decisions in Lawrence and in Bergefell, where they recognize rights to gay, same-sex marriage and sodomy and everything else. They don't even talk about scrutiny. They just abandon it. So we have, in theory, these tiers of scrutiny, which are just never applied, and which a court carves out exceptions to and chops up and slices and dices. And if that's the case, then what's the alternative, right? Do the court simply say that we just defer to the democratic process always? Or do we simply say, we'll only protect rights that are written in the Bill of Rights, we will not do substantive due process? There are not good answers here. And I think Justice Thomas would say that we defer and we don't protect any unenumerated rights. But as it stands now, we have a hierarchy where some rights are preferred and then some rights are not preferred. And that might be great when there's a majority in the court you agree with. And then when there's a majority in the court you disagree with, and they think that other rights are important, then it's not so hot, right? So allowing, I think we're going to see this real soon, allowing judges to pick and choose, like on a menu, I like this right, but not that right, it cuts both ways. He rejects footnote 4 as pure dicta. How did you get that in your head? You in the back? How'd you even do that? I don't want to know. But he rejects footnote 4 as dicta. It's been bothering me all class. I don't know. I don't know. You've been magic your textbook. I don't know. All right. So any other questions on the Thomas dissent? He rejects footnote 4, which is why he has footnote 4 in his neck. That's what he has. Marquis, was your hand up?
Yeah, I was just going to say, so I think I'm pro-choice, but I think if we're going to have laws that tell women what they should do with their body, we should also have laws that men who have like erectile dysfunction should be able to use Viagra. It's kind of the same theory, you know? So
Okay.
they should have to they should have to get permission from their spouse to be able to get Viagra for their erectile dysfunction. It's the same thing.
Permission.
And it's
I think we should end there. That was a pretty good note. I don't think I can top that. I think I'm done. Anyone else? All right. Happy Halloween, everyone. I'll see you later. I'm done. I'm done. Coming up. That's fine.